This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to BRD, twice without our fearless leader, but we're coming on the heels of your birthday, or was it your half birthday?
Yeah, that's fresh material there, Mark. It was my full birthday. Thank you.
How do you feel, by the way? How old are you now?
I feel 100. I'm 37, but I feel great. I was just happy to spend some time with my wife and son. It was a good day.
Nice, that's fantastic.
Nice to work as well. I like working on my birthday.
Congratulations. Yeah, because it makes you feel like you're accomplishing something, obviously.
Absolutely.
So, there's a lot of interesting things going on out there. But one of the things that I actually spent some of my free time yesterday, I argued a case in the Court of Appeal, the State Court of Appeal here in California, but also watched a case that we've talked about before in New York, which was none other than Harvey Weinstein. His appeal, Judge Kamens argued it for him. Judge Kamens is retired in the New York Appellate Department. And I will tell you something, it's always tough to prognosticate how an appeal goes, but he's got a shot. He's got a real shot. I wanted to play some of it, but I think you and I would be you don't have to worry because you're a layperson, but I would probably be summarily defrocked if we played any of it.
Yeah, they put very explicit instructions not to do that, so we decided not to. But I agree with you. I took a look at it as well, and I think that there is a lot of hope to be had if you're on Harvey's team. I mean, there were several of the justices who were expressing concern with some of the decisions that were made.
So basically, the appeal cited what's called, in New York, they call it Molyneux evidence. California, we call it 1101 or similar acts. Federal, they call it 404B, which is similar acts. Basically, what I've always said, and I know I'm a cynical defense lawyer, it's how do we assassinate the defendant's character? How do we dehumanize him so that the jury hates him? We pile on with all the criminal charges. Then how do we taint him even more and make the jury hate him even more? That's enter what's called Molyneux. So the justices are dealing with all of the various acts that the trial court let in under this rubric of Molyneux evidence, similar acts, pattern, MO, identity style evidence. And it was fascinating to watch the justices kind of interplay with the prosecutor and then with retired Judge Kamens, who was arguing for Harvey. By the way, the prosecutor, my peeps tell me she's about to become a federal magistrate. She was, that was what they call a hot bench, and she was magnificent. I mean, poised and articulate and didn't miss a beat. And damn, she, kudos to her. Been there, done that, and that's a very trying circumstance. But they were bringing up stuff that was interesting. They said there were basically 35 other acts that were brought in. One was like the time that they had witnessed Harvey beating his brother. Another was when Harvey had threatened to cut off somebody's genitals. Another was
he left an employee on the side of the road in a foreign country.
Yeah, that was a good one. You remember that?
Yeah.
And one of the justices had one of the great lines, which was, how does threatening to cut off somebody's genitals interplay as to whether or not it was consent on one of the sexual acts? And, and there was some good stuff. And then at what point do you cross the line and say, okay, you've just let in every piece of character assassination that there is, and are we trying him on the charged acts, or are we just saying he's a really, really bad, despicable human, and therefore convict him because that's what we want to do? It's kind of like a Twitter feeding frenzy, if you know what I mean. A bad legal takes on Twitter, whereby, well, he's a bad guy, and who cares if he didn't do this? He probably did something else. All the things that are essentially not allowed or shouldn't be in a courtroom where there are rules of evidence and things of that nature.
Well, he's got the other trial in LA to contend with, but I do agree that there is hope to be had in New York. Do you think it said in one of the articles that I read that it might be several months before these judges issue their opinions? Is that traditional?
Yeah, so in California, if the Court of Appeal doesn't rule within 90 days, constitutionally, the justices don't get their paychecks, which is interesting. I don't know if New York has a similar feature in their constitution, but it's generally a couple of months. Case like this that has kind of some, bright lights on it might they may have already kind of done a give and take, because look, in the courts of appeal, generally, they have clerks who do the memos, who summarize the cases. They know going into it, basically where people are. They use the oral argument basically to test out kind of this theory or that theory, or see what the response is on certain things, use it to kind of probe a little bit. It's one of the reasons I love oral arguments, both watching and participating in at the Court of Appeal, because it's a great intellectual give and take if you've got people, namely justices, and most are, who enjoy that and who are kind of prepared and are ready to ask questions. And there's nothing better from my standpoint. Because I love it, but a hot bench, so to speak, where they are participating, they're asking questions, they're pushing back, they're getting into it with you. I think that's one of the great, intellectual dynamics other than cross-examination at the trial level, because they're really intellectually, you get, 5 minutes on the low side, 20 minutes to 30 minutes on the high side to encapsulate your case and defend your position.
And maybe it's just because of my exposure on this show, but I have always enjoyed it. It can't be because of this show, because from when I was a teenager, I've always enjoyed two smart, well-prepared people having a discussion or an argument on, a set topic they both knew was coming. It's great. It helps me expand my position.
It's exactly what it is. I mean, it's a give and take. Who can get tested, who can't. It's one of the reasons I think they should probably live stream most Court of Appeal arguments, because unlike the trial court, which, by the way, I don't have a problem with that as well, but unlike the trial court, especially in today's day and age, where people's attention span for decades now has been conditioned to do, with a 28-minute comedy or a 40 some odd minute drama, and that's kind of the limited attention span. You get that encapsulated in bite-sized, articulated formats with a give and take. And it's fascinating to me. I mean, it really is. I mean, I could do it. I could do it 3 times a week. I mean, it's just that kind of intellectually rigorous back and forth and challenge, and having to understand the standards. One of the things that we were having an argument about yesterday was that the court was obviously focused in on the Molyneux style things, which is similar acts, the other uncharged acts. But one of the other arguments that was being made, and Judge Kamens kept coming back to it, was the juror who had not disclosed or changed the disclosure from day 1 to day 5 in terms of her book that she was writing.
Yeah.
And his argument is that at first she was asked, well, you're writing a book, is it about predatory men? And she said no. 5 days later, apparently something came out, and the answer, seemingly, according to him in the record, seemed to be that she had changed her position. You remember that?
Yeah, I do. I do. I remember that happening, and I remember, I saw that interaction. He seemed a lot more interested in that one than the justices did.
Which is exactly what we were talking about yesterday. One person I had talked to had mentioned that may be because the Molyneux stuff has a different standard, a harmless error standard, that the juror does not, that's more of a structural issue, and it makes a difference sometimes. But as one of the justices said, what is the line that becomes overkill for letting in all this extraneous uncharged conduct?
Right.
And at that point, doesn't that cross the line between, shouldn't say this, but that's my interpretation, doesn't that cross the line between harmless error, there was overwhelming evidence, and structural error, which basically infects the validity and integrity of the conviction? In his case, that I think is a pretty compelling argument. And the reason why is they found him not guilty on a couple of counts. They were, struggling with the remaining counts. And you can say that you can make, I think, a compelling argument that, the jury was polluted or infected by what one has called the overkill, in this case, of extraneous stuff. And if that's the case, then that would be structural reversible error, in my opinion. And that's, I think, where they're headed, if I had to prognosticate.
And if, let's say, we go a little further down that road and this goes well for Harvey, do they immediately refile?
Yes, it would be reversed. They would refile. They can't refile the counts that he was found not guilty on. So presumably he would get bail, maybe even reduce bail from what he had last time because he was acquitted on some of the counts. His case out here in Los Angeles will not go forward before next summer. So he's entitled to bail there. So with bail in New York, bail here, there is a pathway for him to be out by spring of 2022.
Hard to believe.
Tell me about it. What a reversal of fortune that would be.
It would be. That would be absolutely wild. Well, Mark, I see behind you the beautiful statue indicating you're in Los Angeles. It's your own home, so I'm not going to call you a lawbreaker for the lack of mask, but I'm glad to see you're here. And does that mean I might be seeing you in the flesh tomorrow?
It's a distinct possibility depending on what happens at the office party tonight.
Yeah, so probably not. All right. Well, Mark, you have fun at the party tonight, and we will look forward to having you for the best hour in the universe later this week.
Thank you, Gary. Happy birthday.
Thank you, pal. Bye-bye.
Bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.